Hello friends, I am B.N. Agrawal, ex-Chief General Manager, Finance and Accounts, SAIL Steel Authority of India Limited, Bhilai Steel Plant. I am also Secretary to the SAIL BSP Pensioners Association. I am back on the same very issue, that is pension on higher wages. Last time I covered through a video a detailed note on trust rule trap being played by EPFO, and today I will cover up financial deficit theory by EPFO, whether it is a disguise or a deception. After this video, I will also try to share the write-up prepared by me on these very issues. I will also cover up some other issues in the time to come. We all are aware that in Indian law, it is well settled principle that pension is not a bounty or a matter of grace. It is a hard-earned right and a kind of deferred wages. Consequently, courts have repeatedly held that financial constraints, a crunch, or a budget deficit cannot be used as a valid excuse to deny or delay the pensionary benefits. In fact, EPFO have been using these arguments in the court. We are aware that Employee Provident Fund Organization has consistently deployed the financial deficit theory as its primary defense against granting pension on higher wages. They argue that employee pension scheme is structurally insolvent and cannot sustain the higher payouts required by the Supreme Court rulings. However, a deep audit of legal precedents, actuarial mechanics, and constitutional obligations reveal that this defense to be factually hollow and legally untenable. This document synthesizes the mathematical net surplus reality with the inflation shield effect and reinforces the argument with the doctrine of estoppel, proving that financial gap has effectively already been closed by the Supreme Court's intervention. The EPFO also argues that paying higher pension will drain the corpus, creating an asset liability mismatch. In fact, this claim relies on static, you are aware, outdated valuations, specifically actuarial valuations, and ignore dynamic inflows. I am taking help of my write-up for this video. We all are aware that EPS 1995 has been introduced with effect from 16 November 1995 with a ceiling wages of rupees 5,000, which was subsequently raised to 6,500 rupees in June 2001 and then 15,000 in September 2014, which is prevailing till now. We are also aware that by notification number GSR 134 dated 28th February 1996, a proviso in para 11 after subpara 3 has been inserted, which speaks, I will straight away read out the proviso, that if at the option of the employer and employee, contribution paid on salary exceeding rupees 5,000 per month from the date of commencement of this scheme or from the date salary exceeds rupees 5,000, whichever is latter, and 8.33% share of employers thereof is remitted into the pension fund, pensionable salary shall be based on such higher salary. Now, my argument is this scheme on pension on higher wages have come into the rule book way back in 1996, almost 30 years from now. Nothing new has been discovered by the Honorable Supreme Court in this regard as far as pension on higher wages is concerned. The point is, when this came 30 years back, was an analysis not made on financial implication of the scheme on higher pension? Was government not aware as to what will be the amount of higher pension, how the finance will be met, how the deficit scenario will be discussed and mitigated? These all things were there for last 30 years. No argument have been advanced by the government any time till now. It is all afterthought of the government as to not to provide pension on higher wages to the senior citizens. We are aware the judgment of R.C. Gupta in October 2016. Specific approval was accorded by Ministry of Labour and Employment on 16 March 2017 for higher pension based on contribution of differential wages, that is actual minus ceiling wages, and we were asked to pay the amount along with interest to respective regional offices to be eligible to pension on higher wages. Even at this juncture also, financial deficit was not pleaded. The financial ruin theory was not given much weight compared to the beneficial nature of the legislation. The Apex Court clarified that if the employer had already contributed on actual wages above the ceiling wages to the Provident Fund, the EPFO must adjust the accounts. Financial or administrative inconveniences to the EPFO is not a ground to deny the benefits as per the decision of R.C. Gupta. I will not read out a particular para in circular dated 16th May 2017, which clearly speaks that differential amount has to be paid and those who are doing so will be eligible for higher pension. In Sunil Kumar's judgment, the latest judgment in 2022, more than 3 years from now, the Apex Court did acknowledge the financial viability of the scheme, upholding the increased wages ceiling of rupees 15,000 and allowing EPFO to collect an additional 1.16% contribution from the employer's share to maintain the fund stability. The Supreme Court upheld the right of employees to opt for pension on higher wages. While the EPFO argued about immense financial impact on pension fund, the Honorable Court did not allow this financial burden to invalidate the substantial rights of the pensioners who were in service as of September 1st, 2014. And another important point which I could carve out, the so-called eligible exempted and unexempted establishment have fulfilled their obligations under EPS 95 by contributing on ceiling wages and are squarely covered by the directions issued in Sunil Kumar's judgment. Who are the eligible exempted establishment? There are certain exempted establishment in whose trust rule either nothing is written about pension on higher wages or contribution on ceiling wages. Their trust rule are silent about contribution to pension fund, maybe on ceiling wages or on higher wages, and accordingly, as per the interpretation of EPFO, they are eligible. On the analogy that in other cases like ours, we have written that contribution will be restricted to ceiling wages of rupees 6,500, though it is a totally mirror of scheme, that is EPS 95 of Government of India. Notably, the plea of financial insolvency or deficit have never been raised as a defense regarding this particular category of exempted establishment, thereby validating their entitlement to the pensioner benefits without reservation. Non-extension of similar benefits of POHW to other exempted establishments amounts to direct violation of Article 14 of Constitution of India. Obviously, where from money is coming for this exempted establishment who are so-called eligible, these unexempted establishments who are eligible. Government has never pleaded financial crunch or ruin for this category or this class or this subclass of the eligible pensioners. The actuarial calculation defense being taken by EPFO. The EPFO stands of actuarial deficit by projecting an outdated figure of 2019 or perhaps 2018 would not be of any avail at this juncture, as EPFO repeatedly accepted the concept of defined contribution and defined benefits, wherein payouts are as per predefined and predetermined formula without any reference to financial deficit or ROI theory. We all have seen in number of parliament queries, government have been repeating this reply that EPS 95 scheme works according to defined contribution and defined benefits formula. Financial deficits are not being pleaded here. When defined benefits are as per the formula, where is the question of financial deficit, financial loss, or financial profit or financial gain arising out of a beneficial scheme like EPS 95? Another one, the depletion of pool concept. The Supreme Court 2022 ruling has largely settled the entitlement issues. The current legal battles are not about whether EPFO should pay higher pension. EPFO cannot use the concept of financial deficit to completely override the 1996 notification for eligible member, as the apex court has already validated the right to higher pension. It's a fact. Supreme Court has only validated the rights to higher pension. Supreme Court has not argued on 1996 notification. Supreme Court has not given any clearance to government regarding stopping the pension based on financial deficit theory. We all are aware that rights override or overrule administrative difficulties. In the R.C. Gupta 2016 and Sunil Kumar 2022 judgments, the Honorable Apex Court held that the pension scheme is a beneficial piece of social security legislation. EPFO cannot use administrative or financial hurdles to create arbitrary deprivation of higher pension rights to the pensioners, especially since the 1996 notification did not originally envisage such financial restrictions. We are aware that EPFO advocates have raised the plea of financial exigencies and budgetary deficit during proceedings before various high courts to highlight the fiscal constraints of the scheme. But then, what are the realities? The fund is empty. This kind of argument have been advanced by the learned advocates of EPFO. The Honorable Apex Court and High Courts essentially rules that if a member is willing to transfer the differential contribution with interest, the so-called deficit caused by that individual is mitigated. The court's finding was that deficit should be managed through adjustments in contribution rates, rather than by excluding eligible members. Another argument, EPFO Treasury pleadings is that their treasuries are empty. The Apex Court and High Courts have repeatedly held that as a trustee of the fund, the EPFO's primary responsibility is to manage the fund to fulfill the promises made in the EPF scheme and the mandates of the Honorable Apex Court and High Courts. And today, the U-turn critic, the courts have noted that the EPFO cannot claim a deficit now for a scheme which was mandated to implement since 1996. EPFO must implement the law and the judgments. Financial constraints are not a ground for contempt of law. Having said so, I thought of working out a table showing the financial deficit theory of EPFO, whether it is a deficit or it's a deception, is a disguise. Let me present in the form of a paper after this video. But we all are aware around more than 10 lakh people are affected due to denial of higher pension by EPFO. Now, even if average contribution, differential contribution, I should say, is about rupees 25 lakh, because many people will be depositing 15 lakhs and many people will be depositing something like 60 lakhs also. So, if average contribution is 25 lakhs, there will be a total inflow of about 2,50,000 crores to EPFO. 2.5 lakh crore will be the total inflow of funds to EPFO. They never talk about this data in their workings and in their arguments. Now, assuming a better part of it, around 60%, is paid out to the pensioners in the form of arrears of higher pension, so about 1.5 lakh crore will be paid, leaving a balance of 1 lakh crore to EPFO. Even if EPFO is earning a marginal return of 8% on this amount of 1 lakh crore, so a recurring annual interest income, or maybe the income out of annuity and other things, will be minimum rupees 8,000 crore. Assuming the average annual pension, I am talking about revised pension, is about 3 lakh rupees per pensioner. That means 25,000 rupees per month for a period of 12 months, 3 lakhs. This 25,000 rupees per month may be less or may be more. I have taken an assumed figure of 25,000 as average figure. So total payment will be around 30,000 crore in a year. Now, we all are aware that EPFO has a fund pool, existing fund pool of about 10 lakh crore with them. It is their established figure that rupees 9,92,690 crore is lying with EPFO as on 31st March 2025. I have rounded it to 10 lakh crore. Now, we are also aware, as per the published figure of EPFO as on 31st March 2024, the existing annual income of EPFO is 59,532 crore. I have rounded it to rupees 60,000 crore. It's a little old figure, 2 years old, as it is available. Now, EPFO has also published existing annual pension on ceiling wages as on 31st March 2024, amounting to 23,028 crore. I have rounded it to 23,000 crore. Now, the gross annual income of EPFO then would be 8,000 crore coming from the funds to be transferred by us, and 60,000 is the existing income. So 68,000 crore will be the revised figure, annual figure as income available with EPFO. Gross annual pension payment will be existing payment of 23,000 crore plus revised payment of 30,000 crore, put together will be 53,000 crore annually. Now, we all are aware that when we are given the higher pension, obviously the existing lower pension will be discontinued. I have assumed a figure of 3,000 crore will be the existing lower pension for this 10 lakh pensioners. So that is amounting to 3000 crore. So essentially the annual surplus to EPFO will be 18,000 crore. Even after paying higher pension to all the 10 lakh aspirants across the country, the annual surplus to EPFO will be 18,000 crore. Not discounting so many things in these figures, it is only an estimate. The idea is that whether it is a surplus or it is a deficit to be decided by the policymakers. We all are aware also that spousal pension after the death of the pensioner is only 50%. That means balance amount will go to the kitty of government. There is no return of capital for the pensioners. Now the net surplus reality is what? I said net surplus of rupees 18,000 crore. What is this reality? Contrary to the bankruptcy narrative, the transition to POHW brings a massive infusion of cheap capital to Government of India, 2,50,000 crore. The EPFO focuses on the burn rate, that is outflow, while ignoring the endowment effect, that is inflow. The inflow, eligible pensioners must transfer the differential contribution plus interest for an estimated 10 lakh eligible pensioners with an average differential payment of rupees 25 lakh each. The total inflow is approximately rupees 2.5 lakh crore. The outflow will be, out of this 2.5, the outflow will be 1.5 lakh crore, leaving a corpus of 1 lakh crore to EPFO. As I said, 8,000 will be the income annually. The net result will be, when combining this new interest income with EPFO's existing annual surplus, the scheme can comfortably support the estimated rupees 30,000 crore annual payout requirement. Critics argue that net surplus math is a snapshot that ignores long-term longevity risk, possibly pensioners living longer. This is reverted by the inflation shield. And what is the logic? EPS 95 pensions are generally fixed, unlike government OPS, which is indexed to inflation via dearness allowance relief. We will not get any DA benefit on the pension. It is fixed till we are alive. And then 50% thereafter to the spouse. The financial reality, while the corpus invested in the market and bonds grows with the compound interest and inflation, the liability remains nominal. In real terms, the EPFO's debt obligation shrink every year due to inflation. A rupees 5,000 pension today cost the fund significantly less in real value in 10 years time from now. The EPFO argues that the fund cannot support lifelong payouts. This ignores the mortality dividend. And what is the logic? Not every pensioner survives to the actuarial average age. Everybody will not survive till the age of 80 or 90 or whatever. The financial reality is what? Upon the death of a pensioner, the liability drops to 50% to the spouse. Furthermore, unlike private annuities, the EPFO never returns the principal capital to the nominee. The unused corpus of every member who dies early is effectively donated to the pool, government pool, subsidizing those who live longer. This cross-subsidization ensures solvency without requiring 100% individual funding. Now, having said so, I also thought of comparing EPFO pension with the pension being enjoyed by central government and state government employees. Though the complete data is not available, but as it is available and through the help of I could make out some of the things. Let me try to explain that also. We all are aware of old pension scheme for those who joined before January 2004. What is the benefit? Guaranteed pension 50% of the last drawn basic pay plus DA, nil contribution from the employees, and DA increases twice a year. That means inflation factor is suitably factored in OPS, central government scheme. Government has also brought unified pension scheme sometime in 2025 for those who joined after 1/1/2004. In that, guaranteed pension is 50% of the average basic pay of last 12 months, and minimum pension has been capped to rupees 10,000 per month. Whispers are on to increase this 10,000 rupees pension per month to some other figure based on 8th pay commission recommendation. Now, what are the pension amount being paid to central government and state government employees? You will be surprised to know central government alone an estimated of 2.5 lakh crore being paid to them. State government employees, it is double that is around 5 lakh crore. So total estimated pension on the shareholder, on the taxpayers' money, that is consolidated fund of India, is about rupees 7.5 lakh crore. These figures may be even higher than this. Now, I also could gather total number of pensioners in central and state government is approximately 125 lakhs. 1 crore 25 lakh. Average annual pension payment per pensioner in both central and state government works out to rupees 6 lakhs. In our case, it is 3 lakhs. Revised pension I am talking. That is 50% of the central and state government. Now, if I try to come to the narration or the commentary on this, government employees pension 7.5 lakh crore are taxpayer funded. In contrast to exempted establishment pensions, rupees 30,000 crore, which are financed by the pensioners' own contributions. You might be aware that in UPS, Unified Pension Scheme, government will contribute 8.5% of basic wages to the pool. It is contradictory that government spends 7.5 lakh crore annually without citing financial insolvency. कोई problem नहीं है. Yet pleads a financial crunch in courts regarding private sector pensioners. With government pensions averaging rupees 6 lakhs, that is twice the rupees 3 lakh average pension for EPFO exempted private employees, the claim of lack of funds for private sector is difficult to justify for the government. The vested interest of the state, the government acts as both the employer and the regulator. While it grants its own employees assured pension to maintain administrative stability, it simultaneously supports the EPFO in courts to limit the payouts. Fearing that a massive hike in private pension would require a government bailout of the EPFO, which the Ministry of Finance would never permit perhaps. And a smart point arising out of this, if the state can create a sovereign guarantee for UPS 2025, it cannot claim financial crunch for private employees who are willing to pay their own contribution for higher pension. We are going to pay a very hefty amount to be eligible to higher pension. And we all are aware that this action of government is directly hitting the right to equality guaranteed under Constitution of India under Article 14. The state is creating two classes of citizens: government retirees receiving pension of rupees 50,000 per month and private retirees receiving pension of rupees 3,000 per month today, despite both contributing to the nation's economy. And what is the comparison? The government provides assured pension to its own employees while pleading financial crunch for private employees. This micro classification is arbitrary and discriminatory. And the rebuttal is, while the funding sources differ, that is tax versus trust, the state is the ultimate guarantor for both. Under directive principles, Article 38, Article 39, Article 41, Article 43, the state has a duty, the government has a duty to ensure a decent standard of life for all the workers. The state cannot act as a benevolent guardian for its own employees while acting as a rigorous litigant against private citizens, senior citizens, I should say. Having said so, I also thought that I should also try to, work out some legal scrutiny of the case. We all are aware the landmark judgment of DS Nakara in 1983. The Constitution Bench of Honorable Supreme Court ruled that a pension is not a favor or a charity and it does not depend on the employer's goodwill. Instead, it is rightful payment for the services already rendered by the employees in the past. The court also emphasized that a pension is a retirement benefit that aligns with and promotes the goals of the Constitution and it stabilizes a legal right for the pensioner. Actually, this particular case is the basis and the genesis for pension, a decent pension. We are all aware of R.C. Gupta judgment also. Only a half para I will read through. My write-up will speak about it in detail. In R.C. Gupta judgment, the apex court held that higher pension is allowed subject to the employee willing to pay the differential contribution along with interest. No financial, jugglery, no financial ruin, no financial crunch or constraint have ever been pleaded before the court. And even if it has been pleaded, it has been negated by the court. We are aware of Sunil Kumar's judgment in 2022. The Supreme Court addressed the financial deficit theory with a nuanced approach. While the court did not give the EPFO a blank check to deny pension based on fund scarcity, it did acknowledge that fund must remain actuarially sound. Means, court is and court was quite aware of the financial issues before giving such decisions. Court said that actuarial sustainability is a valid concern. Court acknowledged that EPS 95 is a defined benefit scheme based on pool fund and not an individual saving account. The court accepted the EPFO's argument that if a large number of people suddenly claim higher pension without having contributed proportionately in the past, it could cause an actuarial imbalance. The court noted that the 2014 amendments which sought to cap pensions were intended to maintain the financial health of the pension fund. And that is the reason court asked us to pay the differential wages along with the interest to regional offices of EPFO so that there is no sudden shock on the fund. And deficit cannot defeat statutory rights. Despite acknowledging the deficit, the court held that financial concern cannot be used to retrospectively strip away rights that existed under the 1996 notification. Since the proviso to para 11.3 was active for nearly 20 years, 96 to 2014, the EPFO cannot claim surprise or bankruptcy to deny those who were eligible during that window. The court struck down the cutoff date of 6 months for exercising the options, effectively telling the EPFO that they must accommodate eligible employees regardless of the immediate financial burden. And the estoppel defense. What is that defense? We all are aware 1.16% solution given by the apex court. This is the most critical part of the judgment where courts solve the deficit theory to address the financial deficit without denying pensions. The court upheld the requirement for an additional 1.16% contribution from employees earning above rupees 15,000. The court reasoned that this extra inflow would help bridge the gap in the pool fund created by higher payouts. Interestingly, the court struck down the method by which the government implemented this 1.16%, but it suspended that part of the judgment for 6 months to allow the government to find another way to fund the gap, which they did by way of increasing the contribution from 8.33% to 9.49%. 60 months average also has been upheld by Supreme Court. It is again perhaps accommodating the financials of the government. Last year, April 2024, in one of the case in High Court of Delhi by Retired Officers Welfare Society of Indian Oil Corporation versus Indian Oil, this is a big decision. I will only read out 4 lines out of that decision. My write-up will speak about it in detail. That pension is a method of socio-economic justice which enhances economic security in the fall of life when physical and mental prowess is ebbing corresponding to aging process and one falls back only on the saving as observed by the Supreme Court. Thus, any scheme or rule which is the genesis of grant of pension must receive a liberal construction and interpretation. This is the High Court of Delhi in April 2025. Let us see some other cases. The Madurai bench of Madras High Court. We know early September 2025, so many things have been, ordered by the court by that judgment. I will read out one para only, and that is para number 41, which appears to be highly important for this discussion. Contention of the respondent that any payment of higher pension would result in financial loss to EPFO is not accepted, as only after taking into consideration of these aspects, the Honorable Supreme Court was pleased to issue direction to transfer the funds from the trust to the pension scheme, both in R.C. Gupta and in Sunil Kumar case. Therefore, such contention is liable to be rejected. High Court of Calcutta, a bulldozing decision of Honorable High Court of Calcutta in November 2025. The court has strongly observed that PF authorities appears to be acting contrary to the object of a beneficial legislation, and that such a thought process and conduct by authorities charged with implementing social security laws is unacceptable, as it violates principles of natural justice and constitutes an abuse of the process of law. Before Sunil Kumar's judgment, the High Court of Delhi in Bharati Khadya Nigam Karmchari Sangh versus Union of India. Again, the relevant para, important for us, I will go through. Insofar as the contention of the respondent that there will be financial implication and a depletion of the pension fund is concerned, we cannot agree with the said contention. Once we have found that petitioners are a homogeneous class with the employees of the unexempted establishment. The corollary to this is that by virtue of law laid down by the apex court in R.C. Gupta judgment, a right to get enhanced pension has crystallized in favor of the petitioners. This right cannot be taken away on the ground of financial implications. In fact, we are not even sure if there would be any depletion of pension fund, as the respondent have not placed any material or account to substantiate this argument. We are aware that our friends from EPFO are quoting the figures of 2018 and 2019 before the court, saying that there is an actuarial deficit of some 5 lakh crore as per actuarial report, forgetting the fact that their own funds, their own figures state that as on 31st March 2025, there is a surplus balance available in pension fund amounting to 10 lakh crore. This particular judgment of Bharati Khadya Nigam also speaks about some other High Court judgment on the very similar issues. I will not get into those judgments. State of Jharkhand versus Jitendra Kumar Srivastav. The Honorable Apex Court held that a mere executive order or a plea of lack of funds does not constitute authority of law. Ultimately, you should have the authority to reject the claim, and lack of funds does not constitute authority. The Honorable Apex Court has held. The court further observed that attempt to take away a part of pension or gratuity or even leave encashment without any statutory provision and under the umbrage of administrative instructions cannot be countenanced. State of West Bengal versus Harish Chand Banerjee. The government cannot withhold it due to financial instability or administrative delays. Similar case by Apex Court in 2020, All Manipur Pensioner Association versus State of Manipur. State cannot justify differential treatment of pensioners or denial of benefits solely on the grounds of financial burden or financial crunch. Now, having said so, I will come to the concluding part because video is getting longer. I will conclude by 3-4 paras, small paras, that financial irrelevance, the paucity of funds or financial crunch of an employer or the government is an internal administrative issue and does not extinguish the legal liability to pay retirement benefits like higher pension. Importantly, if the EPFO sits on the corpus of nearly rupees 10 lakh crore and cannot generate enough return to pay its members, it is a failure of EPFO's fund management, not a flaw in the beneficiary's rights. Incompetence in asset allocation cannot justify the violation of a statutory contract. Exemption was granted for administrative convenience, not to create a substandard pension Iceland. Obviously, if the parent law, that is EPF Act and schemes thereunder, allows higher pension, the EPFO must comply or dismantle the exempted status of the establishments. That thereby, if we become unexempted, we are eligible. If we are exempted, we are eligible provided nothing is written in the trust rule. We are exempted, but something is written in the trust rule, we are not eligible. So if these are so many ifs and buts, you dismantle the exempted establishment and allow the pension to the pensioner. It is not the fault of the pensioners. The financial deficit theory is an administrative shield, not an actuarial reality. It crumbles when subjected to dynamic cash flow analysis and established legal precedents. I have already narrated about this. And the last, the legal battle is no longer about if the pension should be paid. Should the pension be paid? But how the fund is managed. Important is how the fund is to be managed by Government of India. The deficit is solvable management challenge, not a legal excuse to void the statutory rights of the pensioner. The path forward lies in enforcing the 1.16% solution, maximizing the investment yield of new inflows, and adhering to the constitutional mandate of social security. Friends, I will share my write up also separately, because this was more like a technical issue to be discussed. So I took the help of that write up. I'll share it. Thank you so very much.